this very gruesome rape and murder case of our national capital called Nirbhaya Kand was there in the year December 2012. And after a hue and cry in the society, the rape law needed change, and the government, after hearing the aspect from the society, has appointed Justice Verma Commission to give its recommendation. It has been made very strict and very stringent provisions are taken into the statute. Many a times we merely read the statute book. It is also seen when we practice that many cases where false allegations of rape is also on the rise. In that, the students and the lawyers should be very, very careful that all the ingredients required for the purpose of commission of an offense of rape are there or not. Whether the interaction between the two extreme, male and female, are with consent or without consent. If it is with consent, then it cannot be said to be rape. So these exceptions are very much stipulated in the law, because with the growth of the society, many people decides to live together. Opposite sex decides to live together, and they voluntarily enter into intercourse. If the things are voluntary, it cannot be said to be rape. In my practice life, I have seen many cases where it was a love affair, and later on, due to some discord, a color of very serious offense is being given. But in this, the courts are also very, very careful. They also tend to not jump to the conclusion that yes, rape is there, unless and until it is proved beyond any reasonable doubt. So in offense of rape, these ingredients, whether the victim is actually a victim or not, whether she was an age of giving consent or not, what was the circumstances, are to be seen very, very carefully. Then the medical evidence also becomes very, very important. After the laws has been amended, also the medical jurisprudence for the rape has changed. And now the government hospitals are obliged to give a very detailed medical report of the victim as well as of the culprit or the accused. Because it is an offense where it is taken on the face of it that a gender which is female her body has been compromised without her consent. So, consent is a very, very important part. Otherwise, if the defense lawyer is actually able to prove that actually there was no offense as alleged by any circumstance, then obviously the court will acquit. If it is proved that yes, the act was actually done but it was with consent, with voluntary consent, again it cannot be said to be a rape. And for and foremost, in the case of marriage, like in Indian society, still we see that females below the age of 18, which is the marriageable age, get married due to many reasons, many socio-economic, social reasons. But whether such marriages can be said to be that the person has committed an offense of rape, so again the law has taken care. And strictly marital rape is not there covered under section 375 IPC. When the laws are formulated, the parliament takes care of its socio-economic regions, and that's why for the same offense different punishments are prescribed in law. If it is proved that offense of rape has been committed, but considering the facts and circumstances, the court may grant a lesser sentence that may be up to 7 years only. And considering the facts and circumstances, if the offense of rape is there, even the life imprisonment can be granted. So again, the law is very, very clear, and the sentencing part is also, it's a very, very important ingredient into it. The 376 section IPC, which deals about the sentence, it's very interesting. It's such a huge difference for the same offense. A person is committing the same offense, proved that he has committed the offense, but punishment is merely 7 years, and the same person who has committed the same offense, punishment is life imprisonment. There again, many things, including the socio-economic background, the facts and circumstances of the individual cases, it depends whether the offense was committed with any very grave aspect was also there or not. So these things are taken care when the courts take care of and tries the offense of rape as prescribed in IPC 375. The various courts have held it time and again that society where we are in, the females, the statement given by the female victim who has suffered, the veracity of the statement given by the female victim cannot be challenged just like in other criminal cases. So an exceptional situation is being created by various courts, Honorable Supreme Court, Honorable High Courts, that the statement given by the prosecutrix are given a very heavy weight in itself, even though there are no other, in many cases where no further basic evidences were being found, but merely on the basis of the statement given by the prosecutrix, where the courts have found the same trustworthy, have punished the accused persons. So law of rape is not a static law, it is a developing law. And for the students specifically, it cannot stop, because ways and means of the society, the way influence of internet and the world is becoming very, very close and very open. The ways and means of committing such offenses are also becoming very, very different. So law has to deal, and students should be very careful, being the future lawmaker and law practitioner and the judges, that this law should evolve so that menace in the society can be caught. Thank you.